So, flying under the radar at the Supreme Court is a case that could shake the very foundations of the whole DEI movement, possibly killing it here in the U.S. I'm speaking of the Ames or Ames versus Ohio. You see, Marlean Ames, I'm just going to go with Ames here, or Ames, a so-called heterosexual or normal woman employed by the Ohio Department of the Youth Services since 2004, has sued, alleging that she was reversed discriminated against, meaning discriminated against, but for some reason we must call it reversed. She's suing under the Title VII of the Civil Rights Act of 1964. She claimed that she was denied a promotion and demoted in 2019 in favor of less qualified gay candidates, asserting that her employer discriminated against her because of her sexual orientations. However, she came up against some problems. Lower courts dismissed her lawsuit, citing a background circumstances rule, which was used in some circuits, including the Sixth Circuit. And what this rule essentially does is it requires people in the majority to have extra standards of proof to prove that you're discriminated against, because apparently only the majority discriminates, you see. So you'd have to provide things like statistical data or proof that a minority group member made that employment decision. Now, Ames argued that this, well, let's just call her Marlean, argued that the standard unfairly burdened majority group plaintiffs compared to minority groups, which it does. And so the Supreme Court is reviewing whether this background circumstances requirement violates Title VII's prohibition on discrimination based on protected characteristics, which includes sex and sexual orientation, which it should. The court's decision, expected soon, could resolve a circuit split, as some circuit courts apply this extra standard requirements, while others do not. And by the way, this extra standard, I'm just going to put it out there, it is extremely racist towards white people and people with regular or normal sexual preferences. Now, to dive into this further, I'm going to pull up an article from Legal Insurrection. They are a conservative news outlet. This is by William Jacobson, and their article is titled SCOTUS, or the Supreme Court, is poised to decapitate the legal viability of DEI, so-called reverse discrimination. Let's scroll down here to the meat of this here. Okay, here we go. The leftists who oppose discrimination against minorities but favor reverse discrimination. God, I hate that term. It's just discrimination, regardless of your skin color, against other Americans to promote workplace equity are about to lose a legal leg to stand on. The Supreme Court seems poised in deciding Ames versus Ohio in the next few weeks to decapitate the legal viability of reverse discrimination against heterosexuals, meaning normal people, and give a strong boost to racial reverse discrimination claims as well. Marlean Ames alleged that she suffered employment discrimination as a heterosexual normal in an Ohio state agency that favored LGBTQ plus barbecue employees. DEI-infused bureaucracies often consider such policies an acceptable part of their social justice agenda, meaning they are okay with being discriminatory and racist as long as it's towards white people and people of normal sexual preferences. Now, federal employment law as written, however, protects everyone equally. The legal issue before the Supreme Court was whether, as a member of the majority heterosexual group, Ames had an extra burden of proof in her discrimination claim that an LGBTQ plus person would not have to meet, which clearly that is the case. Ames worked for the Ohio Department of Youth Services, overseeing the confinement and rehabilitation of juvenile felony offenders in the state. She applied for a promotion, but was turned down in favor of a gay person that Ames claims was not qualified for the job. She was then demoted and replaced by another gay person who, again, Ames claimed was also unqualified. Ames sued in federal court, asserting her claims under Title VII of the Civil Rights Act, which makes employment discrimination illegal. But the federal district court threw out her case because of a decades-old judge-made legal exception known as the background circumstances rule. The 1981 rule sets a higher bar for a majority group plaintiff to make a case for plausible employment discrimination. Such a plaintiff must show background circumstances to support the suspicion that the defendant is that unusual employer who discriminates against the majority. And this irritates the hell out of me. An unusual employer who discriminates? What, because you're a minority class, or because you have a different sexual orientation than the majority of people that you normally don't? show discrimination or racism. People are people. Human beings like to be around things that they recognize or that seem familiar to them. This is why people fall into the trap of racism or discrimination. Every race suffers from it the same amount. There is no difference because you happen to have more melanin in your skin versus not on whether or not you're going to be racist. This whole idea is disgusting. And the fact that the court systems have allowed this for over 40 years, unbelievable. And by the way, you can thank the whole idea of reverse discrimination on this a-hole known as Jesse Jackson. This guy was a giant racist, hated white people. And when he tried to run for president, the media went up to him and said, hey, what are you going to do about, your racist comments towards white people? And he said, well, white people, black people can't be racist because we don't have any power. This is where the whole idea got any kind of traction. And now, of course, it's everywhere. But the idea that a minority group can't be racist is in of itself racist. You are saying that, well, because you're a majority, you can't be. It's ridiculous. But it's been allowed to fester in our society, and young college students are being inculcated and indoctrinated with this ideology. That's how you see it spreading as it is now, and social media helps amplify that. Anyway, since Ames, the legal insurrection article goes on to write, couldn't show that the Ohio Department of Youth Services had a history of discriminating against majority parties, her case was tossed. Well, how do you prove that there's a history if you can't bring a lawsuit because there's no history? The idea is retarded. And the Sixth Circuit has a bunch of idiot judges who are also retarded or racist. So the district court's decision was affirmed by the federal Sixth Court of Appeals, where Judge Raymond Kethledge noted the obvious irony that the background circumstances rule treats some individuals worse than others. In other words, it discriminates on the very grounds that the statute forbids, like I was saying. This stuff really pisses me off. Now, why this case matters so much is people who do not like the racist DEI initiatives, meaning people who aren't crazy or bad people, note that a ruling in Ames' favor here will make it easier for those in the so-called majority group employees to file discrimination lawsuits or so-called reverse discrimination. This will help deter more employers from maintaining their DEI insane programs because they will fear litigation from the white male, the white female, the heterosexual people. If the Supreme Court gets rid of this racist background circumstances rule, then the evidentiary bar will become normalized for everybody, meaning it'll be a lot easier to prove racism against white people and those of normal sexual orientation, which means it'll be a lot simpler for them to fight back against the discrimination. Employers will understand that there will likely be more lawsuits, and you're going to see more of them axe the DEI from their data banks. So I am excited to see where this goes, and it's looking like the Supreme Court will most likely get rid of this rule, as they should. Now, before I let you guys go today, just want to make a little note here. If you like this content, I would be extremely grateful if you would share it. You guys are already great in liking and commenting on our videos. If you've noticed over the last 6 weeks, there has been a severe decline in our reach on YouTube, and there doesn't seem to be anything we can do right now to change that. So it would help tremendously if you guys choose to share this video. So if you hated the video, then never mind. Don't share it. I understand. But if you enjoyed it, it would be great for myself and the channel if you would do us the honor of sharing the video. So that being said, we'll see you all in the next video, and we'll find out where everything goes with this case with Ames versus Ohio, because this could be big.